Hello viewers, welcome back to my channel. Today's topic for discussion is contracts according to the mode of formation. Till now we have read according to enforceability, void, valid, voidable, enforceable, unenforceable. Now we'll discuss about mode of formation. So there are three modes of formation by which we can enter into any contract. First is express contracts, that is by words. Second is implied contracts, that is by act or action. And third is quasi contracts, that is imposed by the law. So let's pick one and discuss in detail each. So the first is express contract. So express contracts are the contracts which are made by words, where the offerer or the acceptor shows their offer or acceptance by words. That can be oral or that can be written. So a contract where parties state their terms and conditions and show their assent by words, either oral or written, is an express contract. Suppose I call you over the telephone and I offer you that I want to sell my car to you for $1 lakh. You accept it and say, okay, I accept your offer and I'm willing to buy your car for $1 lakh. So here both the promiser and the promisee accepts the offer by words. So this is a express contract. So it may be either face to face, with the letters, with telegraph, telephone, fax, over the internet, anything. So those are express contracts. Easy enough, right? Now let's discuss the standard form of contract. You must have gone to the bank, and when you go to the bank and want to open an account, generally bank give you a pre-drafted, pre-written form to fill you up. Okay, so when you start filling it, it asks for various information like your name, your address, and various other things like your income and what account do you want to open, kind of all those things. And there are many other terms and conditions related to the functioning of the bank account which you want to open. So all those written forms which are generally pre-drafted, and the various institutions such as bank, insurance companies, railways, they use this standard form of contract. So what are they generally? They are the express contract. They are the form of express contract because the terms and conditions are pre-written, words are used, and it is offered to you, and if you signed it, then it means you accept their terms and conditions and you have entered into a contract. One more example, and which is very common and which you can relate more, is when you set up your mobile, when you download any app, generally there is a screen which shows, do you accept the terms and conditions? Like when you have, if you have the Apple mobile and you start setting up the mobile, it asks to accept the terms and conditions. So what is that? That is a standard form contract. That is an express contract. Apple wants to agree to that terms and conditions, then you can follow, then you can proceed, then you can continue. If you don't accept it, then you cannot set the mobile. So what are those terms and conditions? Generally we don't read it, but if we read it, we came to know that there are so many situations on which Apple have clarified that he won't be liable, that it won't be liable if something happens to this and this. So those are the standard form of contract and they are the express contract. So these are pre-drafted contract forms. They only require filling the blanks and party signing by other party and create contract between the parties. Generally the terms and conditions are set by one of the parties and the other party has little or no ability to negotiate more favorable terms. Like you cannot negotiate, either you have to accept it or you just leave it. So generally they are also called that take it and leave it contract, standard form contracts, but those are valid contracts. So you must be careful before filing these kind of forms, especially when you are going to banks, opening the bank account, and insurance companies taking the insurances. So you must be careful before signing these kind of standard forms because they are the express contract. Okay, so after express contract, let's discuss what are implied contracts. Sometimes they are also called tacit contracts. So where a contract is made otherwise than its words, then it is called implied contract, like where no words are used, but by the act or action of the parties the contract arises. Like the common example is, which we have already discussed earlier also, suppose you wave your hand and you just enter into a public bus. You take your seat, you sit down, and the bus stops at the next stop, and you just want to leave, but you have to pay a fare because you entered into an you entered into an implied contract. Entering into the bus means you have accepted that you will be using the service of the bus, and then in return you have to pay for the fare. So there was an implied contract. No words were used. You didn't say, okay, are you taking me and can you drop me to that place? No, you just entered into the bus, you just sit down and you stop at the next stop. So there was a implied contract. So the next mode of formation is quasi contract. Actually, I will be making a separate video on this topic because this is an important topic and it needs to be explained in detail. But for now, for this video, just understand that quasi contracts are the contract which are imposed by the law. Okay, there is no actual contract. There was no intention of the parties to enter into contract, no offer, no acceptance, but it is imposed by the law. And why it is imposed by the law? On the principle of equity, because law wants that none of the parties should be under any kind of laws. So that's why laws impose this kind of contract. You will understand it by an example. Suppose you go to the market and you found one handbag. Some lady, she just forgot her handbag, but you saw and you take it. When you open the handbag, you found her driving license and you find out that it belongs to Miss Neha. So what is your duty now? You should have called her, or because you found the driving license, you should have take out her information and you should have returned her. So law wants that you should act honest, and the person who lost her item should not be under any kind of laws. So the law imposes a contract on you. The law wants that you should return this back to the person to whom it belongs. Obviously, you are, if you see, you are not under any kind of obligation. It totally depends on your honesty. But the law presumes that there is a contract created between you and the party, and you should just give this bag back to the person to whom it belongs. So if you see, no contract, no acceptance, no offer, no consideration, nothing, but still this kind of action which the law wants you to do is treated as a kind of contract created by the law. So those are known as quasi contract. Generally, there are 5 kind of situations explained by the law where quasi contract is created. As I say, we will be discussing this in detail in my coming video, but for now just read the points. Like, first is obligation of finder of lost goods to return them to the true owner, which I already explained to you by the example. Second is liability of a person to whom money is paid by mistake to repay it back. Suppose I buy something from Mr. A and Mr. B was also sitting over there, but due to mistake, instead of paying to Mr. A, I paid it to Mr. B. So now there is a liability on Mr. B that he has to repay it back to Mr. A, for whom the money belongs. So this kind of situation, this kind of money paying back between B and A, it's considered as a quasi contract. Then claim for necessary supply to a person incapable of contracting or on his behalf. Suppose there was a minor, he don't have parents with him. So if a neighbor, he just take care of the minor and he just bring the food or any other essential items which the minor need, then he has a right that if the minor has any kind of income, then he could have reimbursed himself from him. So those are such a kind of quasi contracts. Then reimbursement of money paid due by another, same thing. Like if the money is due, suppose I have to pay interest to Mr. A because I have taken a loan from Mr. A, but I was not able to pay interest to Mr. A, so on my behalf Mr. C paid it. So now it's my duty that I have to reimburse it to Mr. C. So it's a kind of quasi contract. Then obligation of person enjoying non-gratuitous act means like I helped someone, and when I was helping someone, I was not helping it out of the like, okay, I don't want something in return back. I was thinking, okay, I'm helping you, then you will reimburse me with whatever expense I have done. So those kind of obligations, those kind of non-gratuitous act are also considered quasi contracts. Don't worry, I know you must have not understood it like properly under this video, but because it was a video for like mode of formation, so I have just given you a brief description about what are quasi contracts. We will be discussing it later in my coming videos in more detail. But still, if you have any questions, any queries, please leave a comment on the comment section. And if you want to make a video on any particular topic for the Contract Act belonging to CA Foundation or CS Foundation course, please let me know. Till then, bye bye, and see you in my next video.